Hi everyone, welcome to the Memory Recall video episode 3 of Kononia Criminology Tutorial and Review Center. So today we will discuss salient points of parole and probation. So we had discussed already the difference between pardon and amnesty. Then today let's try to touch the difference of the salient points of these two, probation and that of parole. So let's start with parole. Okay, so you can see on the screen the who are disqualified for parole. But first, remember that parole can only be granted when the convict or the felon who applies for parole already served at least minimum of his sentence. So talking about sentence, remember that parole can be granted only to those convicts with a penalty of more than 1 year up to reclusion temporal. Okay, so more than 1 year or 1 year and 1 day up to reclusion temporal. So for those who were convicted of a penalty of 1 year and less, then they are not allowed or they are not qualified for parole. And first thing, remember that for 1 year and below, those are under the jurisdiction of Katarungang Pambarangay. Okay, so let's touch the first, convicted of offense with death penalty, reclusion perpetua or life imprisonment, because they are considered as determinate sentence. So that's why only up to reclusion temporal penalty and more than 1 year penalty that the convict who applied for parole is qualified. Second, convicted of treason, conspiracy, or proposal to commit treason or espionage, convicted of misprision of treason, rebellion, sedition, coup d'etat, those convicted of piracy or mutiny on high seas or Philippine waters, also those habitual delinquents. We all know that habitual delinquents, or for those, if you wanna asked to expound this explanation, we will have it in a different video. Escape from confinement or evaded sentence, granted conditional pardon and violated any of its terms. Maximum term of sentence does not exceed 1 year, suffering from mental disorder, conviction is on appeal, and those who have pending criminal cases. So I want you to give more emphasis on the enumeration, because maybe the examiners will ask you just some misnomer or just a little tricky questions, and yun pala, disqualified pala sa parole because one of the conditions are in the enumerated one, and then hindi mo na memorize or hindi mo na familiarize, then it's just sayang. Okay, so please give more emphasis on that. Okay, another one is when we already tackled when can it be granted. So what if this is the case? A parolee already granted one, okay, served the remaining of his sentence in the community because already granted parole, but then violated certain conditions of parole. Then what happened? He was arrested. Question, who can order the arrest of the parolee? Okay, so since it's the Board of Pardons and Parole who grants the parole, and since the person is already in the corrections pillar, remember in your CJS, parole is already in corrections pillar, so it's out of the jurisdiction of the court. So it's not the court who will order the arrest, but it's the Board of Pardons and Parole. So once the parolee was arrested, then what will happen? Then the parolee, after sufficient proof that the parolee really violated the conditions, then you will go back to the prison and serve the unexpired remaining portion. So those years or months he or she served in the community will not be deducted in the remaining portion of his sentence, because the law says unexpired remaining sentence. So sayang. So instead na 3 years na lang sana, so he violated conditions on in the second year, so 1 year na lang sana, and he will be released from prison and considered parang ma-ex-convict na, wala nang sentence to serve. But since he violated, then he or she needs to serve the full unexpired remaining portion, and that is 3 years. Okay? So that's for the salient points, the tricky one for parole. So let's jump to probation. So for probation naman, if parole is already in the corrections pillar, the probation is still in the court pillar of our criminal justice system. So probation, we know that it's a privileged and it's not a right. So those only people who have convicts who have a maximum term of imprisonment of not more than 6 years. So dapat ang penalty mo is only 6 years and below. That's the time that you can file for probation within the period of perfection of an appeal. So remember, within the period of perfection of an appeal, and that is 15 days. Okay, so the law says that when you have the option to file for probation, but you did not file and you filed for appeal, and then you change your mind, you withdrew your appeal and wants to file for probation, the law says that it's not allowed. Okay, you cannot do that. But if, for example, you have a penalty which is not probationable, and then when you appeal the case, the appellate court lowered the penalty to a probationable penalty, then question, can you file for probation now? The answer is yes, because in that scenario, in the first place, you have no option at all, but just to file for an appeal. But since the appellate court reduced the penalty, then you can file for probation. Where can you file for probation? In the trial court that has jurisdiction over your case. So you cannot file your probation on the appellate court, but on the trial court that has had jurisdiction over your case. So remember, the law says also that the decision of the grant or the denial of probation is not appealable. So the denial of probation is not appealable. So what's your remedy in case you feel that you are discriminated, or the decision you felt that there's a abuse of discretion? So by jurisprudence, it says there that you can file for Rule 65, a petition for certiorari. So you can file for petition for certiorari under Rule 65 on the ground of grave abuse of discretion of the judge amounting to lack of jurisdiction. So you can file for that, and Supreme Court mentioned in one of his cases that it is allowed. Okay, so disqualification for probation under the new law on probation, RA 1077. So first, those sentenced to serve a maximum term of more than 6 years. We have mentioned that. Convicted of any crime against national security. So remember, national security, but excluding the law of nations. Remember that in Title I, we have national security and law of nations. So the law says, probation says only for those under the national security crimes under Title I. So take note of that. Okay, we also have those who have previously convicted by final judgment, okay, for imprisonment of more than 6 months and 1 day, and a fine of more than 1,000 pesos. So in short, if you have been previously convicted, but the penalty is not more, is 6 months and less, or 6 months and 1 day and less, okay, or a fine of not more than 1,000 pesos, then you can still file for probation. And those who have been on probation once, because you can only be given probation once, and then those who are already serving sentence at the time of the amendment of this decree, so they are not allowed to file for probation. So how about if the probation absconds or violated certain conditions of probation, what will happen? Then the court will order the arrest of the probationee, and then he will be undergoing a summary hearing, okay, in the trial court. And if proven that he or she really violated the conditions, then the judge will now impose the suspended sentence. Because remember, in probation, the sentence has was only suspended. So whenever you violated certain conditions, that the time the judge um, will enforce the judgment of your case, or enforce the conviction. So what will happen if you have already served you're almost done with, for example, you were given 6 years to serve in the community and you're almost done, but you violated the conditions. In the same manner, it will not be deducted because again, your sentence was only suspended. So it cannot be deducted. Okay, so thank you. That's all for the salient points of our probation and parole. So thank you and follow for more.